Good morning, everyone, and welcome to my friend DA Vance. And thank you for participating in this conversation on decriminalizing mental health. DA Vance is in the final weeks of his tenure as Manhattan District Attorney after 11 years of serving in this role. We are so grateful to get the benefit of his experience and wisdom after so many years leading the Manhattan DA's office through a period of historic reductions in crime and enforcement. Thank you also to the Greenburger Center for partnering with John Jay on this webinar series focused on the role of district attorneys in addressing mental health issues that too often are left unaddressed in the community and the criminal legal process. We know that communities across the country, including New York City, struggle to address the mental health needs of their populations. This issue, as many of you have heard in the prior sessions, was one of many raised in a series of convenings that John Jay hosted in collaboration with the National Organization of Black Law Enforcement Executives, NOBLE, last fall to talk about the future of public safety. These public meetings brought together elected officials, advocates, researchers, community leaders, district attorneys, and criminal justice leaders from around the country to talk about challenges in our systems of policing and criminal justice, as well as the investments needed to create safe, thriving communities. The leaders who participated in the Future of Public Safety convenings agreed that police and the criminal justice process are poorly equipped to address unmet mental health needs in the community. This can lead to tragic consequences, as we read in the papers, for people who are experiencing a mental health crisis. Consequently, we need to invest in treatment and services for people with mental illness and address commonly co-occurring issues of substance misuse and homelessness. District attorneys have an important role to play in creating both diversionary pathways for people with mental illness and advocating for more treatment and services in the communities that can prevent contact with the criminal justice system in the first place. I know that District Attorney Vance is committed to treating people with mental illness with compassion and treatment. And I look forward to hearing from him about the work that his office has been doing for over a decade to support safe and healthy communities through diversion and other programs. But before we begin the conversation today, I want to share a bio for DA Vance and our impressive moderator. Since taking office in 2010, DA Vance has expanded the impact of the Manhattan District Attorney's Office beyond the office's traditional courtroom role to encompass sustained investment in communities, reform of the criminal legal system, and proactive prevention of cybercrime, terrorism, trafficking, and over other 21st century criminal threats. In addition to leading landmark courtroom victories in cases including Trump v. Vance and People v. Weinstein, DA Vance has strengthened Manhattan communities by directing aggressive investigations against 11 of the world's biggest banks and investing the forfeited proceeds of their economic crimes in over 50 community-grounded organizations that support young people, crime survivors, and re-entering New Yorkers in underserved Manhattan neighborhoods. DA Vance has added justice reform to the mission of the DA's office. In addition to right-sizing the justice system by slashing the office's total prosecutions by 58%, DA Vance established New York's first ever conviction integrity program, college in prison program, citywide supervised release program, implicit bias review, and equity and social justice advisory board. Under DA Vance's leadership, the DA's office has repositioned itself to confront contemporary threats to New Yorkers, including international cybercrime, white nationalist terrorism, human trafficking, and the national rape kit backlog. DA Vance co-founded and co-chairs Prosecutors Against Gun Violence and the Global Cyber Alliance in Washington, D.C. Cyber Alliance. And in Washington, D.C., he successfully advocated on behalf of New Yorkers to stop the Concealed Carry Reciprocity Act and enact the first ever congressional appropriations toward ending the rape kit backlog. And I had the benefit of partnering with him on that. And it's been wonderful help to support the country in dealing with rape kit backlogs. In 2020, DA Vance won a landmark U.S. Supreme Court case, Trump v. Vance, which established that presidents are not immune from criminal process, and People v. Weinstein, a landmark step in the field of sex crimes prosecutions. During the earliest days of the COVID-19 pandemic, he proactively consented to the release of more than 300 New Yorkers from Rikers, helping to reduce Manhattan's jail population by 45%. He converted the DA's office in West Harlem into a hub for a major food bank site and successfully lobbied the U.S. Small Business Administration to reverse its exclusion of people with criminal history from the crucial Paycheck Protection Program. DA Vance is a graduate of Yale University and Georgetown University Law Center. And as I mentioned, we also have an impressive moderator for today's event, Greenburger Center's Executive Director, Cheryl Roberts, who is passionate about this issue. And in addition to serving as the Executive Director of the Greenburger Center, Cheryl is the Corporation Counsel for the City of Hudson, New York, and she previously served as a town judge in Columbia County, New York, and served as counsel to committees in both the U.S. House of Representatives and the U.S. Senate. So we have two great people to lead us in a lively conversation about this important issue. So I'm turning it now to Cheryl to start the conversation with DA Vance. Thank you.
Thank you so much, President Mason, and good morning, DA Vance. It's good to see you. Thank you for being here. We are looking forward to this conversation and learning more about your office's policies related to the decriminalization of mental illness. This is the 5th conversation, not the last. We're going to have 2 more, which I'll tell you about at the end, but it is the 5th conversation we have had with New York City's DAs, and we're pleased to be partnering with John Jay College of Criminal Justice. We're particularly pleased that President Mason provided those opening remarks, and I wanted to just take a moment to give some background on President Mason before we get into questions with DA Vance. So Carol Mason was nominated by and served with President Barack Obama as Assistant Attorney General at the Department of Justice, where she headed DOJ's Office of Justice Programs and oversaw an annual budget of $4 billion, which supported an array of state and local criminal justice agencies, juvenile justice programs, and services for crime victims. President Mason also oversaw the National Institute of Justice and the Bureau of Justice Statistics, and led the department's work to address the issue of community trust in the justice system. In May of 2017, Carol was appointed as president of John Jay College. So thank you, President Mason, for partnering with us. It's our honor, and thank you for your introductory remarks. So DA Vance, I wanted to get right into the conversation with you and start by talking about the Manhattan Mental Health Court, which was begun in 2011. You launched that initiative. You were a big part in that. So can you tell us why you initiated it and how you helped start it? And tell us a bit how the court works. For example, does it handle misdemeanor and felony cases?
Thank you, Cheryl. Good morning. And thank you for including me today. And to President Mason, thank you for your lifetime of public service and commitment to criminal justice. We are very, very lucky to have you in New York City as president of John Jay, and your college has been an incredible partner with our office, and I'm pleased to have you here today hosting us all. Cheryl, in 2011, we worked with the Office of Court Administration as well as all the other essentially stakeholders in the justice system, including the institutional defense providers and others. And I think everyone recognized that there is a significant issue with regard to the intersection of people who are arrested for crimes and those people being connected in some way to issues of mental health, or as President Mason said, homelessness or addiction. And that there was a need to address these cases, not simply with traditional prosecution tools of simply prosecution or non-prosecution, but to embrace what by 2011, I think had been recognized widely, the need for prevention strategies and therapeutic strategies combined, unfortunately, with the criminal process in order to both serve the interests of the community in getting better outcomes for individuals who are charged with violent and felony offenses, as getting better outcomes for the community and for the individuals who were under arrest and charged, with the hope that the process could end up being one where there was a sort of a restoration of that individual's life to a normal and positive forward progress, and that's really the genesis of it. I think it's now embraced literally all across the country, and I certainly, with Manhattan, certainly wasn't the first court that dealt with mental health, but it was something that we championed with our justice partners, including the defense bar and the courts, and we're very pleased that that it's been operating now for 10 years. I think, Cheryl, your viewers today probably know quite a bit about how a mental health court works. And as I'm not a regular practitioner in the court, some may know more than me. But fundamentally, one has to be over 18 years old. One has to be charged with a felony offense. We did not accept non-violent felony offenses in the first year or so of our operation. And that was really a funding issue. The source of the funding restricted what kinds of cases we could take. Subsequently, we now deal principally with felony cases. I'm not aware that we have misdemeanor cases in this court at all. We have several other initiatives that we have funded through our Criminal Justice Investment Fund. We have an Alternatives to Incarceration unit that deals with felony cases that may not rise to the level of being eligible for mental health court, but do have considerations, including mental health. And so that there's another pathway for review in our office for those cases, as well as a Manhattan Justice Opportunity Center, which we also funded through forfeiture, which deals principally with misdemeanor cases. So what we've tried to do, Cheryl, is to, the mental health court really is designed to deal with, I think, some of the most difficult, and now some cases involving some violent activity, which is a very serious issue, and so they tend to, I think, be quite serious cases. But to offer other ways to address defendants who may have the complex of issues around mental health, homelessness, drug dependency, and the like, find other pathways to deal with those cases that don't necessarily rise to a case that would be eligible for the mental health court. One has to essentially be capable of taking a voluntary plea. And so these are not cases where there are 730 exams that are pending. And I think the listeners know that 730 is a mental competency exam for an individual to participate as a defendant in the court process. And the process takes roughly 1 to 2 years. I think there are 4 stages that Judge Mershon and the court has created with regard to how the individual proceeds from the bringing onboarding of the individual to the ultimate and hopeful exiting of that individual into back to the community, employed, and as in many of our cases, very successful outcomes. Since we have started the court in 2011, our office has referred 633 cases. We've reviewed 633 cases for the mental health court since 2014, which unfortunately is the year when we started keeping better records on what we were doing. So since 2014, we've reviewed 633 cases. We have referred our office to Judge Mershon, the judge who is responsible for the mental health court, 295 cases, which is roughly 46% of that total number reviewed. Ultimately, the Manhattan Mental Health Court accepted, of that 295, 187 cases. And of that 187 cases since 2014, 100 Manhattan Mental Health Court participants have graduated from the program, which I think is a remarkable success rate, and really I think in some large measure due to Judge Mershon's handling of the court part and his ability to bring all the participants to their best efforts in their work.
Thank you for that overview. I'm wondering, before we move on to the next question, can you give us a sense of what percentage of your total caseload involve people with mental health, and what percentage of that is referred to the mental health court. And I'm interested to know if you have the statistics, what percentage may go to your other diversion efforts for misdemeanors?
Cheryl, I don't have those statistics at hand, and certainly they are, since 2014, we now have the ability to generate probably statistics, although I'm not sure, I can't say that we actually track a case with a flag related to mental health issues. I just don't know how it would be coded at the beginning, but in any event, here's something that is something that I think is very important in the answer to your question. When our mental health court was initiated, the court provided us only 50 slots to participate in the mental health court at any given time. Now compare that to Brooklyn, which has, I think, 100 slots. Our mental health court meets once a week. Compare that to Brooklyn, where the mental health court meets 5 times a week. So we've had 5,600 felony arrests, let's just say roughly this year in Manhattan. We have 50 slots that are reserved for the mental health court. So the answer is a very small percentage of individuals have the possibility of being referred to the mental health court. That's a function of what's been made accessible to our office. And with regards to the alternatives to incarceration and the Manhattan justice initiatives, I honestly can't give you a percentage of exactly how many cases that is of our overall caseload. But as President Mason said, when I came into office in 2010, the office prosecuted, accepted, received, and prosecuted from the police roughly 96% of the cases that the police brought into our office. Fast forward to the end of 2019, we had reduced that number from 100,000 roughly to 48,000, and as President Mason said, reduced it another 10,000. That was principally focusing on the decision not to prosecute and to find alternatives to prosecution, alternatives to traditional enforcement for traditionally lower level offenses, but which were the large part of the police department's enforcement activity, particularly marijuana and what we call theft of services.
I just want to go back to one quick point. You said you have 50 slots. I'm sorry, I might have missed this. Is that a function of OCA giving you those slots, or who?
That's a function, as I understand it, of OCA giving us those slots. And that's my understanding. Now, 50 slots obviously it may be what Judge Mershon is capable of handling in his otherwise busy docket. But I think, Cheryl, just stepping backwards and looking at this from a distance, our justice system is not effective in dealing with mental health disorders or homelessness or necessarily those folks who are drug dependent. And this is a historical problem. The issues are enormous, and I wouldn't pretend to the audience that that everything is going perfectly. It's not. What I believe we should be having, and I've spoken to President Mason about this, I really think we should be having what some people would call a Marshall Plan, a generation-long investment of hundreds of millions of dollars, perhaps billions of dollars, focusing on mental health, focusing on drug dependency, focusing on homelessness. It should be a national effort. And until the country commits those kinds of resources as among its highest priorities, we are going to, there are going to be disappointed citizens who are going to look at our justice system and look at our mental health courts and understandably be critical of essentially the narrow scope in which we operate and the time where we receive these individuals, which is typically at the end of a long, it may be at the end of years of untreated substance, mental health disorder, and other issues.
Well, I can't agree with you more on the last piece of it. We're all for that. So I think you're very right. takes more than a village at this point. So, Dee, I want to get into some of the criticisms that you've alluded to from mostly the defense bar. So, the defense bar has been critical of your office over the years and has expressed some deep frustrations with the process of gaining access to the Manhattan Mental Health Court, which they attribute to policies in your office that they say severely control and ultimately limit entry to the mental health court. They have said that these policies result in long delays in reaching decisions about whether someone will be diverted, and once in, can result in poor outcomes for their clients. And they note that these policies are not in place in other counties. And from what we've heard from other DAs, I think that's probably right. But let's talk about this. So the defense bar points to two policies that are particularly problematic for them, and they are records access and what are known as proffer sessions required by your office. So I want to break those two policies down a little bit. I'm going to try and explain them and really focus on the concerns that have been raised. And then I want to have a conversation with you about them. So the first relates to records access. The defense bar alleges that your office requires the defense to provide voluminous, unredacted, confidential mental health records before deciding whether to allow the accused to meet with your assistants for the so-called proffer sessions or meetings. In other New York counties, it's my understanding that clinicians and healthcare professionals, not assistant ADAs or assistant district attorneys, get this information to prepare evaluations regarding the accused's history, their diagnosis, and whether they can be effectively treated. So it's the clinicians, not the ADAs, that are getting the information and making the decisions. More concerning, the defense attorneys say that this sensitive information has been used against them when a treatment offer is not given. So the second policy relates to proffer sessions. So first, there's this disclosure of records. ADAs look at that, and then they make a decision whether to essentially, as I understand it, invite the defendant to participate in the proffer sessions to ultimately determine if they get diverted. So my understanding again is, in order to gain admission to mental health court, defendants must agree to up to 2 proffer meetings where clients are expected to fully admit their guilt to the charges without any promise of a treatment or entrance to mental health court. And then they're asked to sometimes discuss deeply held trauma in a non-clinical setting. So given those policies and that focus of what I understand their criticisms to really focus on, let's talk about the records access. Why not give it to clinicians to evaluate and then give you a recommendation?
Well, Cheryl, first of all, I think the clinicians do get those records. I mean, ultimately, the individuals are evaluated by an expert staff of clinicians who themselves make a recommendation to the court. The question is, why should the district attorney's office have access to any records, and what's the value of that? The answer has several parts, Cheryl. And you also talked about sort of, it's, first of all, we start with the difficult situation where we have 50 slots. In other words, we have to make determinations of who we are going to recommend to the court to refer of many individuals who may be interested. We only have 50 slots. So we need to get, one point is we need to get as much information as we can about the individual whose lawyer and he or she is seeking referral. Secondly, and because of trying to make intelligent decisions, informed decisions about who our office should recommend, I think it does become relevant for us to understand, for example, if one is in Rikers Island, is this person receiving mental health treatment in Rikers Island? Is he or she participating, or has he or she refused such counseling? Is he or she on medication in Rikers Island, and has she or she refused to take their medication while in Rikers Island? The failure to do either of those two things, I think, presents a potential problem for that individual participating completely with the mental health court requirements. But I would say this, so it's an issue of informing our office. We're not making treatment plans. We're not making clinical assessments. We're not determining whether someone has a diagnosable mental illness. But we are trying to be as informed as possible and about whether or not our recommendations are sound. The court relies on us in terms of our referrals to the court and our position and the confidence of our referrals when we make them to the court. I can't speak for the other DA's offices, and there are excellent DAs in other offices. But I do believe, Cheryl, that our responsibilities as prosecutors are to be making, and as I say, many of these cases involve violent conduct, slashings, assaults, pushing people onto subway tracks, serious injury. We need to be making informed judgments as an office. And if that requires us to see records, to make assessments about whether or not this individual that the program both fits and is the right opportunity for this individual, I think that aids us in making those decisions. I understand there are folks who may disagree with that. Secondly, in terms of, I think, was delay one of the issues that you raised in your question, Cheryl?
I think delay has been also an issue that has been raised, yes. Mhm.
Okay, well, let me just speak to delay, and I know then you want to talk about the interview, the proffer process.
Right. Mhm.
You know, I've looked at the numbers from 2014 to 2021, and I think they're not easy to say on a Zoom call, but when I look at the average number of days for our special litigation section, which is the group that does these internal evaluations, from the point where there's a request by the defense counsel for referral to when our office makes the decision to the court, in 2014, that was 11 days, 2015, 6, 2016, 22, 2017, 88, 2018, 87, 2019, 120, 2020, 97. So those numbers range from 11 to 120 between 2014 and 2020. The average time between when the defendant is arraigned and when the request comes into our special litigation section for review, that is the point where the defense lawyer says, now I'd like you to consider this case for review. In 2014, that was 253 days. In 2015, 272 days. In 2016, 231 days. In 2018, 216 days. In 2019, 243, and so on. So Cheryl, what we see is, with regard to the length of time in the review process, I think the reality is that the greatest length in time is actually that period of time between arraignment and when the request is made to our office to consider for referral, and that our office, I think pushes forward and does the best job it can in conducting the reviews as expeditiously as possible. Now, why does it take 200 plus days for a case to get to our office for review by the special litigation? There are many reasons for that, and there's no specific one reason, but reasons include the defendant was not fit under 730 for a number of months during that period. The defendant may have been out on a warrant for a period of time. The defendant was not stable or did not warrant mental health treatment, despite the defense counsel's urging. The parties have tried to work out a disposition that their client considered, and then that disposition did not go forward, and the defense lawyer is asking now for a review by our office. And obviously in 2021, COVID shut down our processes, and there's been obviously an effect on mental health court since then. So there are a number of causes for the delay in the process. I believe our office works as quickly as it can to move the cases through its review process, and I think that review process needs to be thorough. In terms of the question of why ask for proffers? Cheryl, when you have 50 slots in your court, the easiest thing to do would be to review things on paper. And a paper review based upon someone's history says one thing. I think that our assistants in our Special Litigation Bureau actually feel that the opportunity for them to meet with an individual gives our assistants the opportunity to actually try to understand them and understand their situation in a direct and personal way, which is different than a review of simply paper records and making a judgment. When an assistant meets with an individual and gets a sense of who or she is and the trauma she or he has experienced in their lifetime, or the struggles they've had with addiction, when that individual in the process expresses remorse or realizes the importance of having treatment to having a fuller life, a defendant stops being just a defendant to a prosecutor or just a statistic. That defendant then becomes more of a person. And then there is hope associated with the evaluation by the prosecutor. And I can tell you in my experience, when cases have come to my attention, where I've been asked to review decisions by defense counsel on whether an individual should be permitted to go to refer to the mental health court, and some have involved various serious offenses. The interview process and our decision to agree to referral was instrumental and important in our confidence in making a judgment in what is, let's all understand, a very risk-filled proposition. If a defendant fails or commits a violent offense while in the mental health court, that failure is part of rehabilitation. I think we all understand that. But these programs exist at the discretion of the courts and often of the legislature. And so we need to be making informed judgments to understand the risk that we are taking as an office representing the people of New York County, and the responsibility that's been entrusted in us, that this individual is likely to be a successful candidate from our perspective. And we have that responsibility. I can't, every district attorney's office, to my understanding, ultimately has the right to refuse to make a referral. The DA has a veto. And in order to exercise that veto responsibly, I think the DA has to be informed. And the interview process, in our experience, is an important part of that process. I cannot speak, Cheryl, to the question of was information used to a defendant's disadvantage. All I can say is when those are very fact-specific situations that I can't address on a Zoom call without understanding the case and what happened in the particular circumstances. I understand the concern. I was a defense lawyer for 20 years before I became the district attorney. And I appreciate the defense lawyer's perspective on how they think the best way their client should go through these process. But I'm no longer a defense lawyer. I am a lawyer who's now responsible for a public safety and a significant public safety component with regard to a population that is a difficult population to manage and to get successful outcomes. And I think we do the best we can.
So I want to do a couple of follow-up questions. So on the point about whether information is used against a defendant who doesn't ultimately make it into mental health court, are there at least any rules or processes in your office that that information that is divulged in a very sensitive conversation shouldn't or can't be used by prosecutors later?
Cheryl, I don't know the answer to that question, but it's something that I will follow up on after this Zoom call. In a typical proffer situation with an individual not in the mental health court concepts, there are a proffer session is essentially a voluntary discussion by the defendant with his or her counsel to the prosecutor. There are ways in which information from that proffer session can be used subsequently, and there are restrictions in ways that it can't be used. So I don't know exactly what the nature of the agreement is that's signed, but I think it's a very relevant point, and I'll follow up on it.
And just a quick follow-up on that. So it sounds like if it's correct, a guilty plea is, or admission of guilt is a part of that proffer session on the defendant's part. Again, it is, I assume that if they are not accepted into mental health court, that admission is struck as somehow, cannot be later used against them. Is that the case? Do you know? Or
well, again, I don't know the exact restrictions, but I'm fairly confident that the office is not going to conduct a proffer session, have someone acknowledge guilt, reject that person, and then use that acknowledgement in a subsequent criminal process. That would not be my understanding, but it's a very fair question, and I should get an answer to it.
Mm-hmm. Quickly, just to go back to the delay comment, help me understand the process. So you said it sounded like the longer delay is for many reasons between the point of arrest and the point of actual request by the defense counsel for a participation in the mental health court. So is it at that point when the defense attorney requests that this records requirement and proffer session kicks in?
Well, in the process when the case then is referred to our office for review, there is a period of review for our office, and it would be during that period when there would be a request, not for every record, but request for records that our lawyers feel are relevant to helping them make a decision. It would be during the time when we were reviewing the case itself that we would make this request for records from counsel for the defendant.
Got it. I just wanted to know when that review begins. Is it when the defense counsel actually says, I want this person in mental health court, or is it sometime before?
It would not be sometime before,
Okay.
unless there were some other discussions between defense counsel and the prosecutor where that issue would come up.
So do you have clinicians on your staff who could be there or perhaps evaluate this information so that your ADAs wouldn't be privy to every single detail of their past?
We have clinical professionals, and I don't think our staff of clinical professionals is at the level that the court system has, or that other providers have. At the end of the day, I think this is an issue of informed judgment by a prosecutor's office who is asking to make a discretionary decision on difficult cases. And I think the concern by the defense is, I understand it. I've spoken with our prosecutors who run our unit. I understand their perspective. You've raised very fair questions about whether there are written rules about the use of these documents that are reviewed. But at the end of the day, it's not designed to trap individuals who are applying. It's not designed to punish them. The folks who work in our unit do that work because they believe in this work. They are not working in our office or in the special litigation unit because they are trying to keep people from getting mental health treatment to resolve their cases fairly. They're in this job because they want that to succeed. And in order for them to make the best judgments for there to be success, they believe that review of some essential records is necessary for us to make informed recommendations to the court.
Okay, so let's move on to another topic, forfeiture funds, which, there have been opinions on both sides of this about your use of the forfeiture funds. But I have to say that, you did put your money where your mouth is for $40 million of it anyway to the mayor's behavioral health task force in 2014. You funded that, and that task force looked at, among other issues, ways to reduce the number of people with mental illness entering the criminal justice system. I sat on that task force and advocated for diversion of people with serious mental illness with higher level felony charges I had just come off a listening tour with Francis Greenburger in 2013, and we looked at places all around the country and where they were doing this. So I was probably naive, thinking that we could kind of deal with this population then. Unfortunately, the day before the report was released, I received a call from the then director of the task force who said they had decided not to include diversion options for this population, like our Hope House model, because it was, quote, too heavy of a lift for them at that point. You know, I think what we saw from the administration was, at least initially, a real focus on people with lower levels of mental illness through the Thrive program. I think that's changing a bit with Susan Herman, which is good, but I think this administration really missed the mark on dealing with people with serious mental illness. I understand, as you mentioned, there's risk, there's a hesitancy about diverting and dealing with this population. But I would submit, you know, ignoring or delaying addressing their needs seems to me inhumane and potentially unsafe for the community or the person living with mental illness. And I have to bring up Anthony Scott, who, of course, was a person with a long history of mental illness. He became the 14th person to die at Rikers by suicide. And he was someone who had a case pending in your court, and he was on bail for an assault of a nurse at a psychiatric facility where he was in mental health crisis, which the whole thing seems absurd to me, that someone's in mental health crisis and, you know, hurt someone and then goes to Rikers. And obviously we can't have nurses hurt, but there's something very wrong with this system. So as a prosecutor, you are tasked with doing justice. So what does justice look like for this population, for someone like Anthony Scott? Or what do you need as a prosecutor to do justice in these cases that you may not have now?
Well, first of all, I agree with your overall premise that the system is not doing enough. And we talked about that at the beginning. So I think our office did, as you say, you know, we committed considerable funds to focus on this issue for the city of New York, $40 million. And that funded supervised release, and it funded a whole range of issues. So it's something that we obviously put our money where our mouth was. What does justice look like? Justice looks like having a much more robust safety net upstream in communities, in schools, that to identify and address issues of mental health, drug addiction, and homelessness in the intersection of the three. That's what a healthier society looks like. And that's why, as we spoke at the beginning, that requires enormous commitment of people with vision, like Francis Greenburger, like yourself, who are going to take a generational look at this and understand that this is a Marshall Plan requirement in order to address what on the streets both defender groups, individuals arrested, and the public are enormously concerned about. This is not going away by half measure. This is only going away and be dealt fairly when we are providing equal graduation rates in high school graduates in inner city and equal employment rates, independent of race or ethnicity. The big picture issues are what I think are causing the failure to address the big picture issues are at the front end are causing for a certain percentage of people these deep problems at the back end. In Mr. Scott's case, he had an extraordinarily long criminal record, including violent felonies, extraordinary, a huge amount of failures to appear in court. He assaulted a nurse in the case in which he was arrested, and tragically, he committed suicide, not in Rikers Island, but in the detention cell in Manhattan. Tragic case. No, you are absolutely right. Tragic case. And how did Mr. Scott get to a place where he had the number of bench warrants and the number of convictions is a startling number. I just can't remember it, but it's a startling number. That's a failure of many people and many institutions. I really don't, in some sense, Cheryl, I don't know what more to say. You know, we are clearly in Manhattan. This is not the final chapter or the best way that these issues can be resolved. It's not. We have 50 slots in one of the busiest counties in the country, going through a violent surge in a once-in-a-lifetime pandemic. No, we are not equipped to manage the scope of the challenge around mental illness, homelessness, drug dependency that we have. And anyone who, and I'm not despairing, but we are kidding ourselves if we think this is the best we can do. It's not. Our effort as the Manhattan DA's office was to invest significant funding in areas that touch upon mental health and homelessness and drug dependency with our forfeiture dollars, because I think that's the way I can best address these issues outside of the court process.
Okay, I have some more questions, but there's a lot of questions coming in, and unfortunately, I have to look down at my phone. They're sending me questions, and I have to look on the chat. So I apologize for looking down, but I do want to get to some of the questions from the audience. So just bear with me for 1 second. Okay, so has there been any follow-up with the 100 clients who graduated from the mental health court to collect? And are there any stats on recidivism rates?
I'm sure there are. I don't have them with me.
Okay. Here's a question there are cases where the arrested must plead guilty to greater crime than the one they are accused of in order to qualify for mental health court. How can that help the accused person already suffering from mental illness?
That's a very it's a very fact-dependent situation. I need to know what the actual facts around the arrest were, what is charged, and what the facts are sometimes different. Sometimes what is charged is less serious than what actually occurred, and sometimes it can appear more serious. So I don't know how to answer that question without knowing what that case is and what the specific facts are.
Okay, fair enough. So what kinds of qualifications do the clinical staff at the DA's office have? Do these staff have clinical experience from community mental health, community substance treatment programs, et cetera? And are they being supervised by licensed LCSWs and licensed clinical supervisors in their roles?
That's an issue. I do not have the detailed factual answer to that question, but I'm happy to find it and get back and provide it to you, Cheryl, and you can place it out in a way that you feel is appropriate.
Yeah, we need to actually get a spot on our website that provides these questions that were not answered. We've had them from other DAs too, so we'll try and do that. What is needed from OCA to increase the number of mental health court spots significantly to match the actual need?
Well, look, Brooklyn has 100 spots, as my understanding. We have 50. I think if you were to ask Eric Gonzalez, and my bet is that when Eric was speaking to you in this group in September, he probably said that the need in Brooklyn far exceeded the amount of spaces that they had in Brooklyn. I mean, I whether it's 100 slots or 50 slots, these don't match the need. So I think there has to be a desire by OCA and all the parties to the protocol that we find a way to increase funding and increase capacity. That would be what is required and is no doubt something that the court has considered, but it's not yet in place.
Yeah, it sounds like you almost need another judge in Manhattan to do mental health court, a second mental health court. But okay. What are the challenges with 730 exams? Is there a way to improve the process?
Again, I'm not an expert in 730 exams. And so my comments are really anecdotal on this. I mean, 730 exams are exams to determine whether one is competent to stand trial. And that process takes, I understand, anywhere from 6 to 8 weeks. So that's a process that adds a significant period of time to any evaluation where there's a 730 exam somehow related to an individual later being considered for mental health court. I mean, my view over the years is that the 730 exams and those doing them, which is a court function, are highly competent individuals. And they do their job very well, and they're making honest and credible recommendations to the court on competency. So I don't think it's clearly not a function. It's clearly a function that's important and needs to be supported, not diminished. But it historically in Manhattan, the same people who were doing the 730 exams were also the clinicians evaluating the applicants for the court, for the mental health court. And so that was the history in Manhattan. The same people were doing two jobs at the same time. And 730 exams, I think, in some sense, took priority over examinations or recommendations by the same staff to the mental health court. That has changed, I understand. I think we actually now have a new provider that has been selected by the city to do mental health evaluations for Manhattan cases. I think that's a relatively recent decision. It may be within the last year. And I hope that will, by removing the court staff and their multiple responsibilities from the process, will enable us to take the 730 exam issue sort of out of a delay factor in mental health court.
Are there any crimes or alleged crimes that you categorically exclude from your considerations, such as sex crimes involving?
I think that there are general exceptions, including sex crimes, domestic violence, and I believe arson is a crime that is excluded. I'm not exactly sure why, but there is a limited number of exceptions. Generally, the exceptions that are apply to exclusions in many discretionary programs that individuals who are charged may apply to.
And so that's a function of your office, not anything OCA would impose.
That's a function. I'm not sure whether Cheryl, I don't know the answer. I don't know the answer whether OCA has a different view on that. I just know that is the exclusion. My guess is it's the exclusion for all the DA's offices, and it may well be an exclusion that the court, agrees with. I haven't spoken to Judge Brashan about it.
I'll just say very quickly that the Greenburger Center is hosting a program on November 17th on paraphilic and sexual disorders, and how and when individuals charged with these offenses can be diverted safely. It's going to be a fascinating program. It's 90 minutes. I think we will need more time than that, but I think it's an issue we have to come to terms with as well. So hopefully people will tune into that. So we have about 5 minutes left. I wanted to ask you to, as you prepare to leave office, to reflect for us for a few moments about your time in office. What things do you think you did well? What things do you think not so well? What things do you think, if you had known now that, then you would have done differently?
I think the 12 years I've been in office have been some of the most challenging 12 years in criminal justice, certainly in the lifetimes of many of us. And the last 6 years, I think, have been particularly fraught in the country and in the criminal justice system. So I think it has been obviously an honor to be the district attorney, and I'm very grateful for the opportunity to have been the district attorney. And I am excited for the residents of Manhattan that the office will move on, and another individual will come in and he will raise the bar, as I tried to do, to raise the bar for my predecessor, Bob Morgenthau. And I have every belief that that will happen under Mr. Bragg. I think there's much to be proud of in what our office has done during the 12 years. And I think, without repeating what President Mason said at the beginning, I think the office has a footprint there is no office in the country that handles the variety, the complexity, the scope in terms of local, national, international criminal justice investigations, prosecutions, and prevention. And I think my goal when I became Manhattan DA's office was to take what I thought was the best office in the 20th century and state prosecutors, and all state offices are great, but every DA will tell you their office is the greatest. To take what we thought was the greatest 20th century DA's office and make sure that it was one of the greatest 21st century DA's offices to deal with crimes that really hadn't been the focus of a DA's office previously: cybercrime, sex trafficking, terrorism, the intersection between terrorism and cybercrime, and the like. I was very proud, Cheryl, of our investments through first of all, the courageous work of our assistants in investigating and prosecuting huge foreign banks for extensive criminal misconduct, and prosecuting or settling those cases to a total of $14 billion in fines, half of which went to the federal government and half of which went to essentially the state of New York. And those were landmark prosecutions that really mattered, and that I think changed the attitudes of international banks about whether or not whether the U.S. meant anything when it had sanctions legislation preventing foreign individuals or organizations associated with countries or individuals designated with terrorism to use our banking system. But those funds, those that came back to our office, were invested in the communities of Manhattan. Significant investments in NYCHA, $100 million to help the 15 highest crime NYCHA developments increase their security, $100 million to help the NYPD create a modern mobile platform for all of its officers, and then $250 million, as President Mason said, investing directly in 50 grassroots community organizations, along with the hundreds of other millions of dollars that our office has invested in supporting the city's efforts around supervised release. Those investments I never would have predicted in 1,000 years when I was elected DA in 2010, that we would have the ability as a prosecutor's office to look beyond the courtroom, to look beyond our traditional role as the prosecutor, and essentially be a factor and formidable figure as an office in focusing on fighting crime by preventing crime through support of communities that were most at risk. And those are things that I'm very proud of, and I'm grateful to my assistants and my professional staff for the work that they've done in the 12 years. That many of the good ideas, if not all of them, came from them, and some of them, like the Rape Kit Backlog, a national Rape Kit Backlog initiative President Mason spoke about. And that just doesn't happen. That doesn't happen without a very smart, dedicated, imaginative team.
So we have just 30 seconds, something you would have done differently or better?
What I would have done differently and better, I focused very much on race and whether there was implicit bias in our office's prosecution policies when I came into the office. It was a reason why we brought Vera in to do a racial bias analysis of the office. It was why we reduced our low-level prosecutions from 100,000 to 50,000, because those were disproportionately impacting communities of color. But I hadn't looked inside the office, and it was not until after the George Floyd murder that I really understood the impact of the social justice issues around race and unfairness in our justice system, how they were having an impact on those who were in the justice system themselves and actually acting as prosecutors in the system. And I feel I did not, I had wished that I had been much more aggressive in outreach and understanding what men and women of color were experiencing within our office in terms of opportunities for advancement, in terms of making sure that their experience was what they deserved it to be. And I believe I could have done a better job than I did on that for a long time. Our creation of an Equity and Social Justice Advisory Board, which is a group of both lawyers and non-lawyers in the office, to have a hand on the steering wheel in policy and to be able to make recommendations to me directly about policy changes that affect social justice and justice in the criminal court system. And the recommendations that have made thus far to me have largely been instituted. So those are things that I wish I'd done earlier.
Well, thank you very much, DA. We are so grateful for your time today. I wish you all the best in whatever endeavors you take on next. Thank you also to John Jay, the team at John Jay and my team at Greenburger Center. We will continue this conversation with DA-elect Bragg in January. We'll get you that date at the end of the week. I hope we will finalize that. We also will have a final program in this series with the public defenders in January as well. So thank you all so much for tuning in. Thanks to the audience for your great questions, and I wish you all a very good day.